Hey guys, today we are going to talk about striking out. What is striking out? Striking out is a court application to cancel a pleading or part of a pleading. It is usually used to cancel a statement of claim because of various reasons, which I shall discuss later. Order 18, Rule 19 of the Rules of Court provides that a party can strike out a pleading, that means cancel a pleading, if it discloses no reasonable cause of action or defense, as the case may be. If you want to know what is a cause of action, you can watch the video in the link below on what is a cause of action. Basically, it means a legal basis. You can also strike out the pleading on the basis that it is scandalous, frivolous, or vexatious. Number 3, you can strike out a pleading if it may prejudice, embarrass, or delay the fair trial of an action. Number 4, it is otherwise an abuse of the process of the court. What is the purpose of this court application known as striking out? It is basically to filter out BS lawsuits, okay? Lawsuits that have no substance. For example, I have people wanting to sue restaurants for bad service, who want to sue people for showing them the middle finger. These are BS lawsuits, okay? So the court has this mechanism to filter out, to cancel out all these lawsuits. To succeed in a striking out application, the pleading, okay, it has to be plain and obvious that it is unsustainable. I'm going to talk about the first limb, okay, which is no reasonable cause of action. Lord Pearson Drummond, in the case of the English case of Jackson and British Medical Association, stated that a claim should be struck out only if, upon examination of the allegations, it is found that the alleged cause of action is certain to fail. Next, what is frivolous and vexatious? It simply means obviously unsustainable or wrong. Chief Justice Yong Pang Hao, in the court case of Goh Kun Swan and Heng Gek Kiao, said that an action would be vexatious if the party bringing the lawsuit is not acting bona fide. Bona fide means genuine, okay, and merely wishes to annoy or embarrass his opponent, or when it's not calculated to lead to any practical result. I will now talk about the fourth limb. It is an abuse of the process of the court. In the High Court case of Gabriel Peter and partners and Wee Chong Jin, the Court of Appeal stated that the process of the court must be used bona fide, that means genuinely and properly, and must not be abused. The court will not prevent the improper use of its machinery. It will prevent the judicial process from being used as a means of vexation and oppression in the process of litigation. I'm going to discuss with you some examples of pleadings that I have struck out. The first, a client of mine was sued for alleged misrepresentation. Under the law of misrepresentation, representations have to be of a past or present fact. They cannot be future matters because nobody can predict the future. Only God knows the future. So if someone makes representations to you about what is going to happen in the future if you sign this contract, obviously the whole lawsuit will fail. As you can see from the statement of claim that I have reproduced over here, the plaintiff, the person who sued my client for alleged misrepresentation, the plaintiff claimed that my client represented to him that the company was performing well in terms of its business and will continue to perform well and generate high profits. How can anyone predict the future? The plaintiff also alleged that my client claimed that if he invested in the company and becomes a shareholder of the company, he will get a 100% return on his investment within 1.5 to 2 years. The plaintiffs also claim that my client represented to him that if the plaintiff manages to successfully recruit a student to join the company, the plaintiff would obtain a profit of about 10 to 20,000. So obviously these allegations all relate to the future. They are not past or present facts, okay? The very most that you can argue would be promissory estoppel, which in any event is not a cause of action. You can watch the video I made on promissory estoppel. It can only be used as a shield, not as a sword. I will next talk about another lawsuit where I had to strike out the statement of claim because it had absolutely no basis. Basically, the plaintiff who sued my client, they were neighbors, okay? They were selling similar items, and the plaintiff didn't like my client for various reasons. So he wanted to start a lawsuit to sue my client, to harass her, when he actually has no basis of harassing her. So what did he do? He sued my client for defamation. My client essentially put up a banner outside Haji Lane. Choose your favorite pop-up canvas. For more designs and purchases, please proceed to number what Haji Lane. There's nothing defamatory about this statement. Basically, under the law of defamation, defamation means you say something bad about someone which is untrue. There is nothing defamatory about choose your favorite pop-up canvas and proceed to whatever address. And then the statement of claim, which you can see here, continued saying about, oh, this statement was published maliciously, false, intended to cause harm. In consequence of that, the plaintiff lost business. Basically, it's BS. So I had to take out a striking out application. Let me discuss the procedure for striking out application. To take out a striking out application, you have to take a summons under Order 18, Rule 19. It has to be accompanied by a supporting affidavit, a sworn statement of facts by the person who wants to take out the striking out of application. The other party who issued the statement of claim that is going to be struck out will have to issue a reply affidavit to address the reasons in the supporting affidavit, the first affidavit, to resist the application, to explain why the pleading should not be struck out. After the respondent issues the reply affidavit, the applicant can then issue an affidavit to reply to this affidavit. After the 3 sets of affidavits have been filed and served, the 2 sets of lawyers have to give written submissions, basically a list of legal reasons supported by case law on why the claim should be struck out, and the other lawyer has to give reasons why the claim should not be struck out. Then there will be a court hearing, okay, where the judge listens to both sides of both lawyers and then decide whether the claim should be struck out or not. What is the cost? Well, striking out is an expensive application because for the applicant, who is usually the defendant, the defendant will have to incur costs for 2 affidavits. The first affidavit accompanying the summons, when he first takes out the application, that will cost about 3,000. And then he has to issue a reply affidavit, another 3,000. Written submissions could cost 3, 4, 5,000. And then there will be a half-day hearing that will be about another $3,000. So for a striking out application, the total bill could add up to be about $12,000. So thanks for watching this video on striking out.